Congressman McIntyre.
Thank you very much, Mr. Chairman, Ranking Member, and members of the subcommittee. I'm honored and privileged to have the opportunity to testify before you today about the Scott Gardner Act, and I'd like to thank my good friend and colleague, Sue Myrick, for her great work on this. And our work together has been such that we hope that we will finally see this come to fruition. This was in response to a tragic accident that occurred in the congressional district that I represent, and what began as a family vacation obviously turned into the worst thing imaginable, with Scott Gardner's life being taken and with his wife remaining in a critical condition in a vegetative state. And what this has done to those two young children is truly something that I think Congress can be in a position to do something about. The drunk driver was a repeat offender, an illegal immigrant, an individual who should never have been in this country in the first place, and to have had 5 prior arrests, all DWIs, and one of those times his blood alcohol content being 3 times the legal limit, a transgression that only earned him 30 days in jail. There's no greater evidence that the immigration system is broken than when an illegal alien who is a repeat offender and has earned himself, for all intents and purposes, felonious action, is able not only to remain in our country, but to continue committing the crime for which he has earned a felony. The Scott Gardner Act would ensure that DWI is grounds for mandatory detention and deportation of illegal aliens. Now, if it's determined that the individual is within the country illegally, the officer is authorized to detain or transport the alien to federal custody, whereby he or she shall be removed. This bill would also improve communications between federal, state, and local law enforcement agencies, and it would allow those agencies and law enforcement to collect immigration information in the course of their normal duties. Let me just clarify something. As an attorney, I can appreciate the concern about the constitutionality, but I also tell you this is about a driving record being made available to stop the senseless and reckless taking of life on our highways. There is no mandate that violates the Constitution. To somehow sit here and act like, oh, we're going to violate the Constitution when this law has not even been tested yet, I think is preempting ourselves and our legislative duty. But to make a background check when there is a reasonable suspicion is not unconstitutional. Common sense dictates that any driver's record for use of our public highways is subject to check. This is not the same as in the court case that has been cited today. The Second Amendment protects the right for the use of firearms. The Brady Act was entirely a different situation that the court was protecting. Use of the public highways is a privilege. It is not a guaranteed constitutional act. It is not under the Bill of Rights, like the Second Amendment, that protects the use of firearms. So the use of public highways is a privilege, not a right. Licenses are issued by the government to allow someone to drive on our highways, and they ought to be checked, especially for someone who has a record of DWIs. In her concurring opinion, Justice O'Connor noted that the distinction here, when she was talking about, and she concurred in the majority opinion on the act that's been cited today, Prince versus U.S., said that was a situation where state and local law enforcement officers must do background checks before issuing permits to buy firearms. That's distinctive language. What we're talking about is checking someone's record after they've been issued a license to go on the highway, not before they're ever issued a license. And I think that's been overlooked today. Also, when we look at the fact that in the language, Justice O'Connor also noted the court appropriately refrains from deciding whether purely ministerial reporting requirements on state and local authorities are invalid. And in fact, she says the provisions invalidated here are those that directly compel state officials to administer a federal regulatory program. Well, we're not asking anybody to administer a federal regulatory program. We're saying check the record and see if this person, whoever it is that has been given the privilege of driving on our highways, has traffic violations. That's not profiling. That's not administering a federal program. That is common sense that a police officer goes and checks a person's record. And in this case, it cost someone their life, and it cost 2 children the opportunity to know their parents. Thank you, Mr. Chairman.